Welcome to Middle Class Matters. Today we will discuss on the continuation of the report on expert committee constituted by the Honorable Supreme Court of India in Adani issue. This is part 18 and final part. Surveillance and market administration measures. Para 36. As regards surveillance actions and the improvements being contemplated to the surveillance mechanism, the committee notes with appreciation the regulatory reaction to events and learnings from the market. The committee would suggest that the element of human discretion should be done away with as far as possible. Para 37. Even with introduction of stock-specific derivatives, the human element for making a choice on whether to provide such an avenue should be nearly absent. Unless there are extraordinary circumstances that would not have been factored by the algorithm by which a stock's qualification for inclusion in the derivative segment is assessed, the inclusion of stock-specific derivatives must be automatic and machine-based. Para 38. On the matter of disclosures, the committee has made its observations in Chapter 3. To perfect the ability of the market to read and study the data that is generated by compliance with disclosure obligations, it should be ensured that all provisions of data should be in machine-readable format and is interoperable across electronic platforms. Without such a framework, regulatory compliance would only lead to pulling up of data in silos of databases that do not talk to one another, rendering the big picture incapable of being discerned. It is noteworthy that a strong feedback on the Hindenburg report is that it contained no new data but was substantially a collection of inferences from data in the public domain. Structural reform. Para 39. There are some wider structural changes that are apt and which have already been recommended by working groups and committees in the past. This committee does not intend to elaborate upon and repeat the merits of these. Such recommendations have already been well articulated with serious intellectual resources having been expended in recommending such changes. Some of these that need specific attention are: A. The creation of a financial redress agency that handles investor grievances across sectors. This could be a first step to an eventual unified regulator, but at the least, it is vital to implement a central redress agency that can focus on investor grievance redressal across sectors. Malpractices such as misselling and pushing of inappropriate financial products can occur across sectors, say in stockbroking, insurance, and in banking. At the enterprise level, the service providers of these respective services could be one and the same. And at the consumer level, the investor at the receiving end of the misselling could be the same individual. However, grievance redressal is split across regulators working in silos. B. Likewise, as seen in Chapter 3, the process for recovering unclaimed private property is spread across agencies such as IEPFA and DEAF. The same successor entitled to the same deceased would have to engage with multiple agencies to recover the assets as a matter of right. This anomaly has to be addressed on a war footing. The committee recommends that either through the aegis of the Financial Stability and Development Council or even by appropriate legislation, this problem must necessarily be addressed with a sense of urgency. C. Equally, in complex enforcement matters where the skill set and expertise of multiple regulatory and enforcement agencies would have to be brought to bear, it would be vital to have a framework by which a multiple agency investigating committee with a temporary shelf life. Just what is required for investigating that particular case may be set up by the Government of India. At the end of the investigation, with the initiation of appropriate proceedings, such a committee must be disbanded. The committee does not see merit in creating yet another enforcement agency, but sees merit in bringing to bear the capacities available to the Republic across agencies to investigate the complex case. The framework being suggested must stipulate criteria by which a case may be referred to such an investigating agency or committee by designating it as a systematically important investigation. The government must be able to resort to such a framework only when the case involved has serious cross-sectional repercussions and would need multidisciplinary skill sets to be brought to bear in a coordinated manner. D. Within SEBI, as indeed any other regulator, the doctrine of separation of powers must be followed in letter and spirit. The quasi-judicial arm of the regulator has to be necessarily ring-fenced so that it is truly a check and balance on the executive arm of the regulator. If performance of the quasi-judicial officers is apprised by the executive arm, the very foundation of separation of powers would be nullified. The FSLRC recommendations in this regard must be implemented. So, the report has been signed by the members on 6th May 2023 and submitted to Supreme Court subsequently. So, this is the entire report, Supreme Court Supreme Court appointed committee report on Adani issue. And they have given suggestions, they have given the recommendations, they have given their findings on the remits of the Supreme Court. Let's discuss in another video about the concise form or a abridged version of all the recommendations of this committee. Please like the video, subscribe to the channel, give your comments, and thanks for watching.